Madame la juge en chef.
Madam Justice, ministers, distinguished guests, good day. My name is Joanne Chaudette, and I'm Vice President for General Strategy and Communications here at the IDRC. I'm here in the name of Mr. Jean Lebel, President, who sends his regrets and who asked me to salute you. I welcome you to this event, which we are presenting as part of our conference regarding legal services, and it's animated by IDRC and an Access to Justice Conference, Open Society.
Beverley McLachlin, Chief Justice of Canada. The second half of today's event will feature a conversation with the Honourable Joseph Kamara, the Attorney General and Minister of Justice of Sierra Leone. CBC reporter Alison Crawford is here to lead the conversation with both of our guests. IDRC is pleased to be co-hosting this event. We are a Crown corporation that supports knowledge, innovation, and solutions to improve the lives of people across the developing world. Specific to the conference theme, we work with partners in Canada and around the world to support better, more inclusive mechanisms of governance and justice so that all people can lead a more secure and prosperous life. We do this by promoting resilience, by helping community groups gain greater awareness of their rights, by helping vulnerable populations access services and land rights, by reducing harmful practices for women and girls, and by promoting effective and accountable justice systems and institutions that respond to the needs of vulnerable groups, especially women and girls. Permettez-moi de décrire brièvement.
Please allow me to briefly describe what our approach looks like as applied to Kenya. In Nairobi, the capital of Kenya, more than half of some 4 million inhabitants of the city live in informal housing where access to justice and basic services such as water and sewers are completely lacking. Research financed by IDRC showed that there was what we call a penalty to poverty, where residents in some of these slums, in particular the Mukuru area, paid more for lower-level quality services than those provided to formal residential neighborhoods in Nairobi. IDRC financing permitted a group of experts in Kenya to propose a series of reforms. The administration of the county responded by starting planning reforms in one area of Mukuru, and we do hope that this will be a model to help marginalized residents in the city of Nairobi.
Leaders of this work is here with us today at the conference. Waikua Wanikoyi, Executive Director of Katiba Institute. The challenges and solutions in Mukuru are present across Africa and around the world. That is exactly why this conference is so important. Where there are common challenges in accessing justice, we must find common solutions. Where there are successful models that benefit one or two communities, we must scale them up to reach larger populations. We will now hear from two people who have much to contribute to this dialogue. There will be a question and answer period with each of our distinguished guests, so please be ready with your questions. We are grateful to have Alison Crawford with us today. Ms. Crawford is a national reporter in CBC's Parliamentary Bureau, where she covers the RCMP, justice, public safety, and, of course, the Supreme Court. It is now my pleasure to introduce to you the Right Honourable Beverley McLachlin, Chief Justice of the Supreme Court of Canada. Chief Justice McLachlin studied at the University of Alberta, where she earned degrees in philosophy and law. Early in her career, she practiced law and for 7 years taught at the Faculty of Law at the University of British Columbia. Her judicial career began in 1981 when she was appointed to the Vancouver County Court and shortly thereafter to the Supreme Court of British Columbia. She rose to become Chief Justice of the Supreme Court of British Columbia, and in 1989 was sworn in as the Justice of the Supreme Court of Canada. And in 2000, she became the first woman to be appointed Chief Justice of Canada. Madam Chief Justice, we are honored to have you with us today, and it is a pleasure for me to invite you up to the podium with Ms. Crawford to start this wonderful dialogue. Thank you.
I feel like I should move my chair over a little bit more so we could have a good conversation here. All right, so I'm going to start off just talking a little bit about access to justice. It's one of those phrases that can be hard to nail down. Mm-hmm. It can mean many things to other people. Sometimes it's how unaffordable some lawyers can be, uneven access to drug courts or mental health courts, a lack of judges in some parts of the country that are causing delays. What does access to justice mean to you?
Well, it means basically that everybody, every woman and man and sometimes children, will have access to the justice system. It means exactly what it says. It means being able to use the justice system when you have a problem. Why have a big system if half the people in the country can't use it? And that's what access to justice means. So I've been very concerned to make sure our justice system, which is a very good system, is there not only for governments and for large corporations and well-to-do individuals, but is available to individuals when they have a problem. It could be a simple problem like a dispute with a landlord and tenant. It could be a motor vehicle problem. It could be a contract problem. It could be a breakup of a marriage and a custody and support problem. When people have these sorts of problems, and a large percentage, I think it's 1 in 3 people will have a serious legal problem over the next 3 years. I'm not sure of the statistics, so don't quote me on it. But it's a significant number of people. And suddenly, they may never have thought about the law. They may never have thought they would need the law. But they need the law. Perhaps they've been charged with an offense. Perhaps they have a problem with their mortgage or their landlord. Or perhaps they have an administrative law problem accessing the health care they need. It can be any kind of problem. When they need the law should be there for them. That's my conception of access to justice.
And knowing what you do about other jurisdictions, how do our challenges to access to justice compare to other places in the world?
Well, I can't say that I know about all jurisdictions. I've looked at statistics and so on. I think we have a very good justice system in Canada. And is it perfect? No. But it is so much better than one finds in many parts of the world, whether one is talking about expense delay or whatever. On the other hand, there are other good systems. The legal system a country has is a product to some extent of its culture too, and the challenges it faces reflect the challenges that the country as a whole is facing. Now, we have a very highly developed court structure. We have good policing on the whole. We have, and one of the big bonuses we have is basically absence of corruption. And the really big bonus is we have a high level of public confidence right across the board. And that is something that's missing in many, many countries. So we're lucky in all of those foundations. What I think we need to do now is make sure that those very good things that people expect, and thank goodness they do in our society, actually are there for them. Now, our particular problems focus on some of our social problems and the nature of our society. We know that the justice system isn't serving many Indigenous people as well as it should. That is something we as a society have to come to grips with on a whole lot of dimensions, from housing to health to justice. And so that is a special challenge for us. I also, and this is just me talking, but I sometimes reflect on the great wealth that is the diversity of Canadian society. So many people from different cultures and races, and a lot of recent immigrants. But when you think about it, I think we need to educate and inform people about the legal system. A lot of people have come from parts of the world where the judiciary was corrupt, where you couldn't trust the police, and they regard normally the system with some suspicion, and it may not even think it's there for them. So we need to help new Canadians understand our justice system, understand that it's there for them, and that they can trust the courts, they can trust the police, and that they're living in a different kind of society. So I think it's important, the educational information piece is really important too, for Canada particularly.
Yeah, well, you mentioned that confidence in a way is an important aspect of access to justice, because if you don't have confidence in it, you're not going to try to access it.
Absolutely.
Yeah. Now, you're very well known as being a champion of access to justice in Canada. You're very dedicated to it. You've helped implement a national working group, and in 2013, it issued a report that had very ambitious goals, including that essential legal services should be available to everyone by 2018, and that there should be measurable and significant increases to access to justice for family and civil matters by 2018. Can you give us an idea of how much progress has been made in the last 3 years?
Well, I think we've made a lot of progress. The first step was to engage all participants in the justice system and civil society. And because it's a complex problem, and it involves governments, it involves courts, it involves police forces, it involves a whole raft of players. Academics have a role to play. So we can't improve things unless we get everybody involved. So in order, for example, to get better outcomes for resolution of disputes in family matters, which is so important that we promptly be able to sort out custody disputes, that we be able to identify situations of danger for children or need for children, that we be able to sort these things out quickly, promptly, and effectively and fairly. So those are the outcomes I'm talking about. What do you need to do? Well, you've got to make sure the government has to be involved, because they're providing a lot of the services for the courts, and the legislatures may be writing the laws. But beyond that, assuming you've got the right laws in place, there have to be sheriffs and clerks and police and social workers, and there's a whole infrastructure there that has to be able to respond quickly. That's a government problem. It's also a lawyer problem, a law society problem, because people need legal advice and they need legal help. We know that a lot of people are going to court to represent themselves, but we know that the outcomes are much more satisfactory if they have professional advice. So we need lawyers to be part of the problem. They have to be there to be prepared to do legal aid, do pro bono work, that kind of thing. And we need another part of the government puzzle in criminal areas, and sometimes in child and family is legal aid. So my point is we have to get government, lawyers, courts who have to look at their processes. Everybody's got to be in this together if we want to make a difference. And so the first step was to get everybody involved, and we've been really successful at doing that. And in both federally across the country and in different provinces. And I've been really, really encouraged at a host of programs that have sprung up, and actual money and effort being put at different aspects of the problem. A lot of good new practices developing, timelines developed to track how in some provinces how we're doing on reducing delay in, for example, first appearance after a family dispute. There are some concrete measures that we've never been all that techie in the justice system. So, technology is not the answer to everything, but it can help us track whether we're on the right track. And I think that it can help us schedule courts, and it can help us in a lot of ways. So there are a lot of projects going on. I think it's going very, very well. I think we have been making a lot of progress. Where I see the next steps coming is for some sort of national strategy, institutionalization of some of the practices that are developing across the country, so we do more sharing and more study. Incidentally, I should mention there's a lot of young academic lawyers now who are studying this, and this is helping immensely.
Well, I know in Ottawa, at the University of Ottawa, there is a great number of lawyers working pro bono to help Syrian refugees that are coming to Canada.
And then there's Avocats Sans Frontières, which is, it's a program where lawyers go out from Canadian cities and go to countries in other parts of the world and help in different situations. So there's pro bono, both at universities and in legal firms. There's organizations like Avocats Sans Frontières. There's a lot of different civil society sort of organizations and individuals who are taking this up, and they're doing amazing work. Now, it's a huge problem, and it's a diverse problem, so it's hard to say we've solved it. And I don't think we ever will completely say we've got there. It's a process. We're always going to have to continue to work at ensuring that we are providing effective and fair justice in a timely manner, which is what I think access to justice is.
Now, I know people at IDRC are very excited about the fact that access to justice is included in these recently adopted Sustainable Development Goals. What do you think needs to happen here in Canada to meet the commitments at home?
Well, obviously I'm not going to get into political prognostications. That will be that's going to be for our elected Parliament and so on to decide what they want to do. But I think it's a good. Let me say it. I think it's an excellent thing that this has been put on the table, because I believe that you can't have a successful society without a good justice system. And we more and more realize that you won't attract industry, you won't be able to build a sustainable economic, you won't be able to get the right health outcomes. Health outcomes, economic outcomes are tied to a good legal system. So this is important for Canada, but it's important for other parts of the world, and it's important as we go forward increasingly in international ventures and so on. We've got to build a world. If Canada's to be successful as an economic unit in the world, it's got to build structures in other parts of the world where it wants to have mines or where it wants to have whatever, So we're all intertwined, and I think that this universal acceptance of the importance of access to justice is important not only in terms of sustaining our own commitment as a country to better justice, but to helping us as a country operate and work and be successful and contribute to other parts of the world.
Well, since you didn't step into the political arena, I'm wondering what, in terms of what we've learned from our own challenges here in Canada and our successes, are there any insights or advice that you think Canada can give other jurisdictions on their own, search to meet those development goals?
Yeah, well, I do believe that you've got to work hard on eliminating corruption. I think as long as you have corruption in the police and the courts and so on, which is not the case in Canada but is in some parts of the world, it's very difficult to build a good system. It's very difficult to have public confidence. And when the public doesn't have confidence, they don't access the system. So there's the real access to justice problem. Are you going to access a system where you think it's corrupt? No. So I really think somehow each country has to look at its own culture and say, what in our particular culture do we need to really tackle. And so that would, it's not advice, but I'd say that is very important. And then put the resources in, and education and information. We have, and I personally have been involved in education of judges abroad, and it's most satisfying work. It's terrifically rewarding. Educating lawyers, educating judges, respectfully, showing them how we might do things so they can pick up on it and then transplant it into their own way of doing things. And when we do that, we learn from them, because often there are many strengths in some of the on-the-ground ways people have been resolving their problems in less legally formalistic societies, and we can learn from that. It's fascinating and important work.
What would be an example of that, of something where you've been able to, there's been a takeaway for you in a society that has a less legalistic?
Well, I haven't, because I'm rather busy with other things, I haven't really done a lot of on-the-ground work, but Canadian judges have been going to places, let's say Vietnam, where there was a long-term project, the Philippines, another long-term project. There have been a number of projects in Ukraine. And a lot of this work is done through the National Judicial Institute, and it's supported by the Government of Canada. So how does it work? Well, a judge will leave Canada, and she'll go and talk to meet up with the court, and then maybe go to some remote area, and they'll bring 30 or 40 judges to a learning center. Perhaps not at all near a big city, but just judges who are out there doing their work, and their materials prepared. There are obviously there's been a lot of preparation working with judges at the higher levels as to what they want to do. Do they want to do child justice? Where does their focus want to be? So we come in, the NJI would come in with a whole curriculum that has been prepared in consultation and at the request of the country that is seeking this. And then that is, the judges try to follow that plan and see where it takes them. And it's, as I say, I think very rewarding work. And sometimes it's providing resources and also in books and other cases, and discussing how you handle certain situations and so on. Part of it is really talking, maybe over dinner or whatever, about what it means to be an independent judge. What do you do when you've got your courthouse and your lawyer, but one of the litigants comes around to the back door with a chicken to the judge? Do you say, no, I can't do it, or I can't take a gift from you, or how do you do this tactfully? You get a lot of conversations going on that are very, very interesting, and I think the judges will tell us very helpful to them as they go back into their communities and administer justice as best they can.
Sounds really rewarding.
Mm-hmm.
All right, well, I think it's time to take questions from the audience. There are some microphones, 3 microphones, and I'm just going to set out some ground rules. No one wants to hear a speech. So if we could keep the questions short, to the point, and on topic for access to justice. If someone wants to stand at the mic and ask a question, don't be shy. All right, well, I think It's on.
So my name's Aruj. I'm the former Director of Women in International Security Canada. And with that organization, we've been doing a lot of work on gender-based violence against women, access to justice. We ran a national campaign around the Gomeshi situation when that was hitting the fan. And I guess I continue to work on the issue of sexual assault, violence, human rights. That's my area right now. And I guess I just wanted some insight on how, the case that happened and the results and the verdict that came out, it was, I can say, a test, I guess, community sentiments, that it was quite sad to see that, there was an element where survivors were forced to be in a situation where they're obviously becoming more victimized and their issues are becoming really public, and that they had to go to those extents. So from your wisdom and perspective, what do you believe is going to be something that ameliorates this type of situation, especially given the fact that, the percentage of women that report these kinds of assaults, it's often framed as a family or domestic issue. And given the most recent verdict, it's not necessarily welcoming for survivors to pursue justice.
Yeah. Well, it's very, very difficult because on the one hand, you have to maintain the basics for a fair trial. And we've always had, as a fundamental tenet of our criminal system, that before you lock up somebody for a long time, potentially, the charges have to be proven beyond a reasonable doubt. On the other hand, these kinds of charges are among the most difficult to prove because they're often usually in private, there are no other witnesses, and so on. So some people make the point that the criminal law system is probably not the ultimate solution for victimization and so on that goes on. What did I do? Simply because of the very high standards it has to insist on, because what's at stake is the liberty of a person, as well as all the stigma and so on that attaches. I don't have any insights or advice as to how to change it. We have made a lot of changes over the last 2 or 3 decades in our criminal law system. The criminal code is full of them to try to make courtrooms more friendly to complainants in sexual assault situations, to limit the kind of questions that can be asked in a courtroom, to be respectful of the claimants. In some cases, to provide some privacy, certainly for children, things like screens. And there's appreciation in the justice system of how traumatizing it is, how difficult it can be to testify and to answer questions in cross-examination, which are also part of our system. So I think we have and we need to continue to make the justice system as user-friendly, it's a terrible term, but as accommodating and sensitive as possible to the situation of complainants in sexual assault, and we need to continue to work on this. The Parliament has done a lot. There's maybe room for more. I don't know. That's up to them. Courts, in developing the law of evidence, have tried to do a lot. Will it completely remove the trauma? I don't know. If any time you're testifying in a criminal trial, it's going to be some trauma. You're going to have to be cross-examined, and that's basic tenet of our justice system. And so you can't remove all the stress from the system. But I also hope that we can explore other avenues of reducing sexual assault, of encouraging attitudes of respect, of ensuring that, we'll never ensure perhaps, but changing the culture. So I thank you for your question. I feel what you're saying. I wish I could be more helpful.
I think we have another question. My name is Geneviève. I work for Above Ground, which is an active member of the CNCA, so the Canadian Network on Corporate Accountability. And one of the issues that we face with victims and communities we work with is certainly a huge challenge in trying to access justice when it comes to corporate-related human rights abuses committed by Canadian companies operating abroad. And so, Honourable Chief Justice, you rightly point out the importance of working with host states where these companies operate to strengthen the domestic judicial systems. And I was wondering what was your view with regard to how the Canadian system should be reformed in order to ensure that companies headquartered in Canada can be held accountable, and that victims can have access to reparations and to remedy here in Canada. As you know, it's very difficult to bring claims, and there's been no successful foreign plaintiffs that have been successful in trying to bring those to the cases. And so, thank you.
Well, I have to be pretty careful on this because we have a large decision in this area under reserve. And as a judge, I can't really comment on specifics. Again, I would only say that we need to promote a culture within our corporations of respect and on the legal issue of enforceability, I'm afraid I have to say I better not comment at this point, since we have some of this litigation going on before us. But I understand the situation, and I thank you for your question.
Following a Supreme Court.
Yeah, I can't say anything.
There's a lot of stuff on our plate.
Is this on? Can you hear me? Okay. So hopefully this is a question that you can answer. So my name is Sanjay Patil. I'm with the Open Society Foundations. And, when you were talking about access to justice and what that actually means, to my mind, it's very much about sort of reconciling power imbalances embedded in the system. And to my mind, First Nations communities are sort of particularly been marginalized in the past when it comes to access to justice here in Canada. And so I was just wondering if you could highlight some strategies that you think will be effective in particularly cracking that tough nut when we're trying to talk about having them access the justice system. Yeah,
well, we have to make it user-friendly for them, and we have to get more of them involved at all stages in the system. There's a lot of things that are being done. We are training more and more Indigenous people as lawyers, and that's been going on for 2 or 3 decades. And there have been some very proactive programs to take promising young people, instead of making them go through, the 7 years and so on, doing some shortcuts. And as a result of this, we're getting, and we have some wonderful First Nations Indigenous lawyers. And that is very, very important. These people will be accepted, and they understand, and they can work in the communities much more effectively than people from the outside. We also, people are putting together Indigenous legal centers and places where people can come and talk and get help and get information in a way that they're comfortable with. And that's very, very important. There are legal pieces of the puzzle that it may be for Parliament and the legislatures to put in place. In our sentencing, we have a law that says we need to take into account the Aboriginal background. Now, it's difficult to know quite what to do and how to do this, and the courts are working on that, and the Corrections Canada is working on it. For example, I was talking with a lady from Corrections Canada, and she said, well, because of this requirement, we decided that we would do an in-depth profile of every Indigenous person who comes into the system. And she said, what we discovered was that this could, unless it was handled carefully, have negative impacts, because they were documenting things that were not being documented about the lives of other prisoners. And so you had it all there if something went wrong. And she said we had to become sensitive to the fact that this could be used negatively against Indigenous people, even though the intention of Parliament was clearly to use it in a positive way. I just cite that to say it's complex, but it's good that we're working this through, and we have to find ways to make the system not only the system of the white people or whatever label you want to put on mainstream, but also a system owned and recognized as legitimate by Indigenous peoples.
I think we have a question over on this very tall microphone.
Very short person. Hello. I work for the Economic Empowerment Program here at IDRC. Mm-hmm. The World Bank released a report saying that out of 153 economies studied, at least 18 had laws that prevented men from legally allowing their wives to work. 92 economies showed there was at least one law that prevented some element of women's economic empowerment. I was hoping you would be able to expand a little on the barriers, but also spaces for opportunities to make sure that discriminatory laws can be eliminated, that new laws that cover kind of women's empowerment in a holistic, nuanced way. So there's a lot of movement on issues like violence, which of course is important, but obviously there's a huge spectrum beyond that as well. And lastly, on the implementation of law, because it's only as useful as it can be actually put to practice, right? Which is a huge problem in the countries that at least I'm doing research on. Thank you.
Well, I wish I could be more helpful. I'm not an international, human rights specialist by any means. Like you, I'm aware that there are so many different societies in the world, and many of them have laws that are very repressive to women and girls. And there's this what's encouraging, if it is that there's a real recognition broadly now, internationally, through the documents we've been talking about and so on, that discrimination against women is unacceptable. And so we have to use every tool we can, it seems to me, international, national, etc., to ensure that women are able to participate in all facets of society. And we know that this will enrich societies and that the outcomes economically will be better and across the board. But I mean, it's hard work to change people's cultural value set. So we have to recognize that we just got to hang in there for the long term and just keep at it and at it and at it. I think that's the best I can do. It gets very discouraging. I really admire people who are, out there devoting their lives to this, because it is sometimes, I know, slow work, but I think we just have to be persistent because it's the right thing to do.
I think we'll take one last question before the Chief Justice has to go.
Thank you. Trevor Farrow, Osgoode Hall Law School and Canadian Forum on Civil Justice. Chief Justice, one of the themes we've been wrestling with, at least today at this conference, is what would be useful research for governments and policymakers. Is there a particular set of research or kinds of thinking that you're seeing is lacking from the court's perspective that we should be thinking about over the next couple of years?
Oh, I'd like some time to think about that. That's a very good question. I think we could do a little more work on just this off the top of my head, but what would be the optimum normal, quote-unquote, trajectory for a particular kind of litigation? And how can we bring aberrant cases closer to that? That's the kind of research I'd like to do. Just start with a landlord-tenant thing. It may be a month-to-month tenancy, and it's got to be done quickly. So the trajectory should be very quick, and maybe you have a judge on the phone and you have immediate access, and it can be sorted out right then. Child apprehension or something, again, a very short trajectory. But at the same time, you have to preserve the elements that ensure that it's going to be fair. And that takes a little bit of time. So what we're always coming up against is how much time is the right amount of time to allow, or what should be our standard here for getting a certain kind of case through. Now, having said that, I'm not suggesting that every case can be fit into the mold, but sometimes I think we don't even have a very clear idea of what the target is that we should be aiming at. And if there's some sort of research that could be done that would show us what are desirable targets in certain areas, I think that would be helpful. We do a little of this in the criminal area because of Section 11B of the Charter, which says that everybody's entitled to a trial within a reasonable time. And it's been hugely complex. And when the courts are grappling with it, they're always asking, well, what would be a normal intake time, a normal time for a bail application? And, we don't have a lot of research on it. It seems to me, anyway, from what we're getting. So you put me on the spot. I might want to give the question more thought, but that's one thing that occurs to me, Trevor.
Again, on that point, if the public knew what to expect as well, that would help them, with their expectations throughout the process.
Yeah.
All right. Well, I think Chief Justice has to go to another event. So thank you so much.
Thank you. It's been lovely, and good luck.
Thank you. Sure. Photos today. Oh, yeah.
So again, thank you so much for an engaging conversation, Chief Justice. Your experience and insights are a tremendous contribution to this event and this conference. So now it is my pleasure to introduce our second speaker of the day, the Honourable Joseph Kamara. As Attorney General and Minister of Justice in Sierra Leone, Mr. Kamara manages two portfolios that are critical to our focus today. Prior to being sworn in earlier this year, Mr. Kamara was head of Sierra Leone's Anti-Corruption Commission. He was called to the bar in 1990 after graduating with a law degree from the University of Sierra Leone. Mr. Kamara began his law career as a state prosecutor. He later served as president of the Sierra Leone Bar Association as well as deputy prosecutor for the Special Court of Sierra Leone, which investigated war crimes following the country's decade-long civil war. We are pleased to have you here, Mr. Kamara. You bring much experience in access to justice issues, so please join Ms. Crawford, and hopefully you have a good...
All right. Well, I wanted to start off with legal aid because I think that's something everyone here is aware of, the challenges in Canada with legal aid. And Sierra Leone brought in a Legal Aid Act in 2012. And since then, you've established the first ever Legal Aid Board. Why was this so important?
Well, let me start by thanking the Open Society Foundation and the IDRC, together with the Canadian government, for giving me the opportunity to be here. Legal aid is important to us as a government for three basic reasons. To start off with, good governance.
I'm going to interrupt you because I think your microphone isn't on. Is it on? Yep, now it is.
Yeah.
Yep. Sorry about that. When the man in the black shirt comes walking, there's always a technical issue.
Yes, thank you very much.
It's working now.
Yes, thank you. Yes. Okay, I was talking about basically good governance. And
there you go. But before was the setting,
yes.
So it only worked when he tapped on it. That setting.
Thank you very much. I was talking about basically for good governance. Legal aid is good because people need to get access to justice. And justice means the rule of law. And it is also about your electoral rights. It's also about your civic duties as a citizen. It's also about your rights as a woman, your right as a child, and as a government, a responsible government, to ensure that the citizens have equal rights. So yes, basically, it is a good tool for good governance. Secondly, it is key for us. We came to understand that we have overcrowded prisons. Most of our prisons were built during the colonial era. Sierra Leone was colonized. We became independent in 1961, and we inherited these colonial prisons. And for example, the central prisons could only hold 1,500 prisoners capacity. Now there are about 3,000 of them there. And so it is a serious cause for concern. And we need to do something about that to reduce the prison rate in the cells. We also look at it that Sierra Leone has a very high population of illiteracy. And we need to work on that to ensure that people have the opportunity to know what the laws are. Because if you talk about access to justice, It's nothing to me if I don't know the law is there, if I don't know it is beneficial to me. So that is why it is key that we introduce the Legal Aid Act. So part of it could be to enhance people's knowledge, the outreach, legal education. Firstly, you have to identify yourself with your rights. And once you understand those rights, you know that there's a redress. Once there's a redress, you can access that redress. So that is why it is key as a government that we introduce the Legal Aid Act.
What impact has it had?
Significant impact. I'll tell you that, I became Attorney General in January. And to date, we've been able to release over 500 inmates from prison and through legal aid. What is this? We found out that there are certain prisoners who have done their time, they've served their time, even on remand. Because we do have in Sierra what we call preliminary investigations. That is, at a time when you do not take a plea, the threshold there is for you to just to know that whether you have a case to answer. And it's not a threshold of proof beyond reasonable doubt, like in any crime. So if you do not take a plea and then you're put on remand, that is, you have a case to answer, you're sent to jail. You're there for 2, 3 years, 4 years, when maybe the punishment for that particular crime is 2 years or a year and a half. So you're there waiting for you to go to the higher court where you'll be served with an indictment. So we found that there is a couple of those people, several of them, and more or less they were like in a hole. Because until we know about them, we're able to serve indictments upon them, which is the work of the Attorney General's office. So through legal aid, we visit the prisons, we identify these lost prisoners, inmates, so to speak. We identify a couple of them. And every month we ensure that we release them, we get them out. Significant impact. The society is happy about it. And the other issue we're looking at also is the sentencing. You have persons, maybe somebody is hungry, stole a piece of bread, he's sent to jail for 3 years. And he spent a year and a half. We have to look at the sentencing guidelines. And through legal aid, we're looking at the sentencing guidelines, and we're using that to release prisoners from cells. The third aspect, which I think is key by way of impact, is the outreach. I myself have taken the opportunity to visit a lot of prisons. I've also visited the country in a nationwide tour. And I came to find that if you're able to proceed with legal aid and its impact, you need to understand the needs. And how can you understand the needs of the people or the needs of the very persons that justice is meant to serve if you do not feel like them? So during my national tour, I went to the prisons. Big challenge. Visited the cells. Tasted their food. And the things that I learned, one particular case was troubling. It was in Kenema, in the far eastern part of the country. And I went to see the women inmates. And there was this lady with a child, about 3 months old. And the child was born in prison. And I was particularly concerned about that. The child was not meant to go in prison. So there and then I worked on an indictment to be issued, and then she was served with an indictment. She appeared in court and was granted bail. So these are issues why it is important that you go out to the field. Had I go there, I wouldn't have ever known there was a woman there with a kid. And we take it from there. There was another scenario in Bo, which is the southern part of the country. There were a few boys in remand home. And I asked the most youngest of them, what are you doing here? He said he came with his uncle, and they were going up and down the town. They went to a market. And then the uncle got lost. He couldn't see his uncle. And he was there till in the evening. The police caught up with him. What are you doing? He was charged with loitering. And he was taken from the village. He doesn't know anybody in town. So that was another case. I have to ensure that he gets out. So there are particular instances wherein, through legal aid, it has enabled us to get access to the people, access to inmates, and also we're able to talk to people, communicate with them. What are the issues of the law that they need to know and understand? You'll be surprised that in a country where about 60% of the population cannot read or write, so most of the general law is there in black and white. It doesn't relate to them. So they believe in the informal sources of justice. And in that informal source of justice, where they go, it is not well organized in the sense of basic principles of law, like rule of law as you understand them to be. So there it comes the need for paralegals. And I'm thankful that we have institutions, both NGO, the MATI, they are there. We have Team Up for Justice, they are there. They are filling in those gaps where they get access to the people, talk to them about their rights. Let them know, particularly in instance of what we call devolution of property, where it's difficult for women to inherit property back in Africa, in most countries in Africa. We have introduced the Devolution of Property Act to ensure that every woman has equal access to inherited property as any man. So we're working on that.
It sounds as though there has to be some sort of education and outreach so people know what their rights are and know how to access legal aid. How is that being done?
Yes. Well, to start off with, we do have a lot of programs. We work with women. Last week before coming here, we had a big public outreach meeting and with Women for Justice. That's how they call themselves. Significant. Now, women identifying themselves with the law. They're taking the law that they need to participate by understanding what are the issues, what advantages are there for them. And it was a very good meeting, good turnout. Gave them information about the basic rights in the Constitution, what they need to know about it. Like I mentioned, the devolution of rights. I also spoke about the issues of customary law. In Sierra Leone, we do have a parallel legal system. You have the general law, you have the customary law. The customary law mostly is for those in the hinterland and the provincial areas where you do not have magistrates, formal judges, but you have a council of elders, and then you also have, it deals with marriages, it deals with property issues. So we talk to them about that, and we have recognized customary law marriage now in our formal system. Most of them didn't know. Because before, through customary marriage, when the husband is tired with you, he drives you out. That's a divorce. Takes you back to the family. I'm tired with her. That's the end of it. It is no more like that. And most of them didn't know about it, so they were excited. And talks about when you look at inheritance. Somebody will be there with the father, and then the father dies. The brother will come and say, okay, well, I'll marry the mother. And takes over the property. What happens to the children? Most of them didn't know that the law has changed. That now there's recognition of the law. And that it cannot happen like that. So it was good that we went out to talk to the women. Tell them about the rights, that there could be the opportunities. So yes, the outreach has been done so well for us. It is impactful, and we're feeling the weight of it.
So I brought this up with Chief Justice McLachlin as well, the Sustainable Development Goals, which include access to justice. So what's next in Sierra Leone? Like, what are some of the other steps that can be taken to meet those goals at home?
Yeah. Well, we're looking at a reformist agenda in terms of justice. For example, we are reforming the criminal procedure. Yes, we're working on the Criminal Procedure Act. Our laws are old. The Criminal Procedure Act is 1965, and it's now that we're trying to reform and change it. And we're also looking at the Criminal Evidence Act as well in terms of the law, strengthening it, giving opportunities and access to each and every one. Because today we're looking at modern technological age and instances where the best evidence rule can be used more adequately. Access, you can use email to form part of documentary evidence. It is not like that before. And beyond that, we're looking at gender parity. Yes, we've introduced gender laws, and we have a new Sexual Offences Act that deals with sexual harassment, and we've modernized the laws, and we're going out to let people understand what these laws are. And we're also looking at even fiscal management, because it's all part of justice. Accountability. Sierra Leone has one of the most stringent laws in anti-corruption. And fortunately enough, like you may have heard, I was the previous commissioner of the Anti-Corruption Commission. And we have one of the most robust legislations, meaning that we as a commission then, you have powers to prosecute, conduct our own investigations, and charge persons to court. That commission has charged 2 sitting ministers of government, a city mayor of the capital city of Freetown, and many high-profile cases we've conducted. And with huge successes, even there, the outreach was key, because it is all about the perception of corruption and how do we change that side from the people. So a lot has been done in that direction. So in terms of good governance and corruption, the Learned Chief Justice spoke to it, because we have to work on corruption. And we cannot hide from the fact that in Africa, corruption is a significant issue. We have to do something about it. It is just not having the law there. It is ensuring that the law is implementable. It is also ensuring that justice is there, and not just getting the loot away, but also recovering the loot, bringing it back for good governance. And this is where a lot of countries in the Western world, we need support, because most of what is taken out from Africa is brought over to the West in the banks. So we need that money back, so we could be able to develop our people, introduce education. And in Sierra Leone, talking about the sustainable goals, we've looked at education. Now we've been able to ensure that there's a girl child education project, meaning that every girl child goes to school free at the primary level. to encourage women to be capacitated. So women empowerment is key for us as a government. And beyond that also, when we talk about accountability, we're ensuring that for every layer that we want to ensure the youths benefit hugely, because we look at youth as a vulnerable group. And we've introduced a national youth strategy. We are one of the few countries that have a National Youth Commission. And today we've recently appointed a youth as the youth minister.
Some might say we have one of those as a prime minister.
Thank you.
What about the when you're talking about gender parity and access to justice? Is there also a move to try and get more women into law school?
Yes, we do not have the affirmative type of action, but we, as a matter of policy, we encourage a lot of women to go to law school. And even as I sit here, there's a lot of craving of women wanting to join me in the office, the Attorney General's office. And personally, I've prioritized it that I'll take more women than men. Yeah, but there is no affirmative process or policy. But we want more women to be lawyers, and we encourage them to go to law school. And today I can say proudly the previous Chief Justice is the first woman, yes, in the South region. And now we have the Solicitor General is also a woman. The Administrator General is also a woman. The Auditor General is also a woman. So they occupy key positions of strategic governance. And I think it is signal well for the state. And it is very encouraging, and we'll continue to do more.
It sounds as though when you did your tour that you encountered issues that hadn't occurred to you before. Were there any other particular ones that jumped out that you realized, oh, I didn't know, or I didn't know this was as much of a problem as it is?
Oh, yes, most certainly, Ms. Crawford. What we noticed is about delaying trials. Of course, it was familiar, having been in practice for over 25 years, that there is delay in court cases. But I never knew it was that bad. Because when you go out to the provinces, to get even the witnesses to attend court is difficult. Because they cannot use their own money, and they have to travel long distances. So that is why when we talk about access to justice, it is just not about legal aid directly or about representation. It's about having the courts closer to the people, so that they cannot expend so much in transportation. And because when justice is there, it's close. They're able to attend to court. If even they're not litigants, they go to see justice well in their presence. So we've heightened the number of judges. We've increased the number of state councils, meaning government lawyers that are there in the regions. And we've also opened new courts. Yes, but that was a rude awakening to see that it was really that bad. Because there was a particular province when a judge only gets there 8 weeks in a year, and meaning that he cannot even conclude a case in 8 weeks. Yeah. So that particular region would have been without any judgment for like 2 years in a row. So it was key. So we've sent another judge, sent another magistrate, and new state councils to give support to that region. But yes, I was really shocked to see it was that bad in terms of when we talk about access to justice, that the courts were not even there.
Well, you can't access it if it's not there. Yeah.
That's it.
We should open up the floor to questions from the audience. So again, if you can keep your questions short and on point. And we have 3 microphones open, and please fire away. Don't be shy.
Hello, it's so exciting to see what's being done in your country. Is there a role, you mentioned the customary law, and you talked about the need for the courts to be closer to the people. Is there a role for customary law tribunals, such as councils of elders? And I think this might be instructive for us in Canada in terms of Indigenous sentencing circles and things.
Certainly, because what we've done, we've introduced a new Local Courts Act, and in this new local court, we are starting to have judges sit with assessors, and also having legal representatives attend to these local courts. So we're moving the customary, as in customary per se, opening the bracket to ensure that there's greater access and there's greater understanding of the laws as applicable in the general law. So at the customary law level, now we have lawyers representing, and then we also have judges that will sit with assessors, and the assessors are the people who are the elders, like you mentioned in your question. But definitely, yes, we have taken it to a new level, and it's a new strategy we are assessing. So we may not have felt the impact of it as yet, because we barely introduced it 2 years ago. But certainly it seems to be working at this stage.
All right, we have a question in the middle microphone.
Yes. My name is John Sinclair, and I used to work very much in the field of international development in Bangladesh and some African countries. And I'm curious, so whether, and it's partly a follow-on from the previous question, to what extent a country like your own has to be built in, if I would call it simplified, two parallel legal systems. You have a legal system for the urban population, for the population who have access to lawyers and things like that, and that maybe what is needed in a sense more and more is a rural court system, not the traditional court system, which I'm sure existed in your country, like in every country, including here in Canada originally, but a system which is, in a sense, attuned to the needs of the population, the poor, in a sense. And in fact, do you need, and that may be a bit of a radical suggestion, I mean, two legal codes, a legal code for the urban modernized society and a legal code which is more appropriate for the people living in the rural areas?
Thank you. That's a good one. The build-up of the legal system in Sierra Leone typifies the historical background of the country. While it was being colonized, the British clearly separated the western area, which is their own domain, and applied British law, properly so called. And then you have the protectorate, that is the hinterland, and then they use their own customary law practices. And in the course of time, it has grown like that. What we're doing now as a government is to more or less harmonize the two. We've done a new land policy that harmonizes both the land law in the western area and land law in the under the Provincial Lands Act. We also have what we call circuit courts. These circuit courts are going around the country, and they apply general law around the country. So if you have customary law is more or less now only resident with specific communities or tribes, because typical things to do with property varies from one region to another, or from one particular tribe to another. So if you have a case, let's say, for example, a divorce case within a particular community, they rather go to the chief that understands the intricacies of their system, and that works well. So you don't want to destroy that type of entity. So it has been parallel so far, but there's a good margin of harmonization when it comes to land, and then it comes to issues of tort, it comes to issues of the criminal law. But in terms of private international law or private law, you look at divorce, we've maintained the core customary aspect of it.
I was just going to ask if there was a risk of having a two-tier justice system, but as you say, if it's quite limited.
Yes.
And we have another question over here.
Thank you. I'm Aisha Fofana Ibrahim, and a visiting scholar at Carleton, and I'm a Sierra Leonean. I'd like to thank the minister, and he talked about the gender justice laws that have been enacted in Sierra Leone, and he also acknowledged that they're there, but they're not effective. So we know that for sure. I want to talk about what you call it now, what's the law? It's about the Sexual Offences Act. And the Sexual Offences Act, it states that having sex with a minor is a crime. And a minor in Sierra Leone is anybody under 18. But yet we have a government that bans school-going children, 16 and below, or become pregnant, and the people that make them pregnant are not criminalized. So they get punished, but the people that impregnate them do not get punished. So where's the justice there? And also in relation to that, the Parliament did enact or did pass Safe Abortion Act or bill, a Safe Abortion bill, and that was stalled by the minister himself, or was it by the president? I don't know. So if you have a situation where you have tons of kids getting pregnant, they don't have access to legal abortion, and then you ban them from school, where's the justice?
Thank you very much. The issue of banning from school is not an absolute position in law. It is a circumstance that emerged during the course of the Ebola scourge in Sierra Leone. And during that period, it was a difficult, traumatic period for the entire state. And a lot of children were not going to school. There was no school for the whole year, and resulting in a lot of teenage pregnancies. And by the time we reopen schools, we grapple with the issue. Do we have pregnant girls come to school with those who are not pregnant, and they sit together? And the traumatic influence of that and the psyche of education, we struggled with it. But certainly it came to a point we decided it was not banned, that those who are pregnant, and it is also in their best interest that they could go to their own evening classes, after which, the delivery, they can come back to the regular school. So they were specially catered for. It was not banning them from going to school. And in the other aspect of the question, you asked about the sexual offenses and the 18-year-old. We have what we call statutory rape, which is 15 and below. And that if you're caught doing that, it's statutory rape. And it's different. And in the case of 18, if you get pregnant, and if you do not bring an issue of rape, so, I mean, nobody can charge anyone about it. So it is not about once somebody gets pregnant, it means that there is an offense. It doesn't mean like that. So the question with 15 and under, if you get evidence of any form of penetration, then yes, there is an offense. But with 18 and above, you have to come forward with a case. And if there is no case, then you cannot go and start searching. Oh, you're pregnant. Somebody must have committed an offense. It doesn't work like that. If it's a case for rape, yes, we have the Offences Against the Persons Act. It is there. And we also have several of the sexual offenses. This is 2015. We have the one of 2011. We developed it in 2012. It shows that the government is poised to ensure that we have a very firm position against rape and all sexual offenses. And there's another question on the
Safe Abortion Act.
The Safe Abortion, thank you. Yes, the Safe Abortion was a private member's bill. It didn't come through my office. And by the time it came to us out of interest, we studied it. And it is difficult when a private member introduces a bill and it's drafted. They do not take into cognizance the entire laws to ensure that the new law you're introducing is consistent with all other provisions. And if it is inconsistent, you amend those other laws that are inconsistent. It was not like that. Key issue on the abortion law was the definition of what abortion was, and also who could conduct the abortion. Ordinary nurses, CHNs, and even pharmacists. It was too loose a definition, and it was riskier to have let that law become operational. So that is why I personally advise His Excellency the President that I don't think it is advisable the law as is to become law. And we can work on it. That is, it was withdrawn. It came back to my office, and we're looking at it now to see, firstly, to correct the definition of abortion, because another area which was not clear, there was no timing on the fetus. So the law was really loose. There was no timing on the fetus. Because even in the UK, I don't know what the state of the law in Canada is. There has to be time. If it's 14 weeks.
We don't have a law.
You don't have a law. So if it's 14 weeks or not. But the timing wasn't there. It wasn't specific. So a couple of other issues which were technical drafting issues. So we've recalled for the law, and we are looking into it. I believe that. And the other issue which you're familiar with, it evoked so much public ire in the sense of interreligious council. They made so many statements.
That's why we don't have a law.
Yes. And, but what was key in that, significantly, there was no wider consultation. And the very title, the Safe Abortion Act, the very title was offensive. And this is what I thought. The first thing could have been done, like I think they did it in Ireland. Yes, it was not labeled abortion. The word abortion is offensive to many sectors of society. It's offensive to to Islam. It's offensive to Christians. Both Christians and Muslims came together and put pressure on government. So that title could have changed to any other thing. So we're looking into that to repackage it to ensure that, because personally I believe in it, and to see whether we could reintroduce it now as a government bill rather than a private member's bill with the right definitions, with the right security and protection for women.
Thank you.
Thank you, Aisha. Appreciate it.
This debate for sale, you're not here.
Do we have any more questions? We do. Thank you.
Hi. Matilda Cole, Global Affairs. My question really relates to the anti-corruption issue. I was going to target the girl child and the lack thereof of access to education and furtherance of higher education as a result of Ebola and countless number of rapes. Let's call it what it is, rape. That occurred and that took place for younger girls. But let me go to the anti-corruption issue. I want to know from the Chief Justice, how do you measure success? And my question speaks to the fact that in as much as a lot of people have been indicted of corruption charges in Sierra Leone, to date, I cannot identify a successful trial that resulted in punitive restoration of punitive damages. And I'm not, and let me be clear, certain fines were levied. People pay certain fines, but to the extent of their act or what should I call it? To the extent of the charges levied against them, how do you then measure success when so many officials and top officials, for that matter, have been indicted with corruption charges, and at the end of the day, every single indictment, each and every time, result in insufficient evidence? When the evidence speak for themselves very clearly, even the layman can understand it. You can prosecute and successfully prosecute with these evidence laid out before you.
Well, thank you very much. It's a good question. But let us be careful with the facts. And the Anti-Corruption Commission has successfully prosecuted so many cases. And I think I mentioned that 2 city ministers of government have been convicted and sent to jail. And even a city mayor, the mayor of Freetown, the capital city, was also convicted. And the matter is on appeal. So if you say that they are not convicted or that they were, your facts can definitely not be correct. Let us be careful with our emotions into these issues. Because if even you look at the case of the Maritime Administrator, Chief Executive, the late, yes, he's dead now. He was convicted. He paid over 400 million. Yes, there's a lot of money. And you have many, many of these cases. Where I think you could come to closely, if I could get part of your point right, is that sometimes the punishment is not commensurate with the amounts stolen. And that is not an area for the commission. The commission goes to court, makes its case. The sentencing is with the judge. And that's an issue which we're looking at. And I think I preface my comments that one of the things we're working on is a sentencing guideline. We'll have a bail and sentencing guideline that will make it consistent, such that if you're accused of misappropriating X amount, the sentencing should be such that you will be convicted to pay more, twice the amount stolen, or something like that. That is what we're trying to introduce. And in 2014, the Anti-Corruption Commission had 100% success rate. 100% success rate. And beyond that also, Sierra Leone is the only country that secured a conviction for stolen wealth. Illicit acquisition of wealth. Sierra Leone is the only country in the entire sub-region, for the first time, for illicit acquisition of wealth, persons were arrested, charged, and convicted. So yes, there is corruption still. No argument about it. Do we still have to do more? Yes, we have to do more. But let us be careful, let us appreciate the correct facts and not try to mislead the public sometimes what we do not sure about. But if you look at the statistics, you look at the records of the reports of the Anti-Corruption Commission, yes, there is a huge success in terms of prosecutions, huge success in terms of public outreach, but the perception still prevail, and I agree with you. What do we do about it? We've got the laws. We have to ensure that the laws are implementable. The judges have to come on board. They have to give support, like you mentioned, where there is evidence, and there is strong evidence to believe that an offense has been committed. Yes, the necessary thing has to be done. Conviction. There are cases that we didn't win at the Anti-Corruption Commission, yes. But the lawyer is as good as his case. You cannot be expected to win each and every case that you have. But definitely, We need to do more. I agree with you. There is corruption. Yes, we will fight it. I will continue to do that. It remains part of our constituency. Even as a Minister of Justice, it will continue to be part of my constituency until such a time I find somewhere else.
All right. And I just have one final question to wrap up. We've talked about the Sustainable Development Goals. Is Sierra Leone working with other partner jurisdictions to share knowledge at this point?
Oh, yes. We have what we call the Mano River Union. These are 3 states, Sierra Leone, Guinea, and Liberia. And we do share part of the laws is very similar with Liberia. Guinea is French, the French code, but we do have a lot of engagements. And even with Ghana, we have what we call mutual legal agreements, to sign up mutual legal agreements. And we do have the ECOWAS, that is the Economic Community of West African States. We have its own protocols that we all work together. And we have international conventions that affect the states there. Together we have the African Union. So all of these are areas of collaboration between the states. And Sierra Leone more particularly is a very leading country in ensuring that we share good practices, especially in the areas of the fight against corruption, good practices in terms of democratic values. We've had now, I think, 3 successful elections in the last few decades. And it's a state that is coming out.
Very busy.
Very busy. We are holding our ground.
All right. Well, thank you very much for being here with us. Can we all thank the Minister?
So thank you, Mr. Kamara, for such an interesting discussion. That brings to an end the program for this afternoon. Thank you all for bringing your questions, your ideas to the conversation. And I want to take a moment to thank our speakers, the Right Honourable Beverley McLachlin, Chief Justice of Canada, who had to leave for another event, and of course the Honourable Joseph Kamara, the Attorney General and Minister of Justice of Sierra Leone. And thank you, Alison, for moderating our conversation this afternoon. This event comes at a perfect time for the conference schedule. You've had a full day to immerse yourselves in the issues, and the conversation here this afternoon has inspired great energy, and I hope that you have a wonderful discussion tomorrow. Thank you.